morning, Mr. Khan.
Morning, my lords. My lords, I propose in the remaining time left for me before my learned friend takes the floor to do as follows: to grapple with the issue of the burden of proof and how it, in my submission, it should operate when you have parties who dispute how widely, in fact, a particular PCP was applied.
Yeah.
Without covering ground we've already covered, tend to be short. Then go on to my submission that even if the ET chose the formulated the pool incorrectly in principle, it nevertheless on the facts applied what was a defensible.
Sorry, I'm having trouble hearing.
Sorry. The second point I wish to make is that even if, as a matter of legal principle, the ET chose a incorrect pool, on the facts before it, the pool was correct and defensible and would have led to the same outcome. Then go on to explain briefly why the EAT's decision to substitute was not the correct one. And then finally, I can deal with briefly the material differences which my learned friend raises in his additional reason number 2. My lords, the burden of proof.
Right before we go on to that,
Yeah.
You kindly provided overnight the list of issues and indeed your opening note. Thank you. And before we leave that point,
Yeah.
what we see from that is that you were contending in the agreed list of issues for the wide pool. Is that right?
Yes.
All the respondents directly and indirectly employed staff.
Yes, that's how the list of issues reads. And
So we're beyond by now how anything reads.
Yeah.
That's what it says.
I accept that.
However, the respondent then offers 3 alternative pools. The first of which is the narrow pool. Paragraph 8. I've got it on screen at the moment.
Okay, thank you, yes.
So either all those who are seeking work, whether as employees of the respondent or employees of Vinci, I'm not aware that Vinci is involved anywhere else, but suggests the narrow pool. All of those who are employees of Vinci and all those who are employees of the respondent. Can't quite grasp the difference. But thirdly, anyone who's employed by any organisation which provides a service to the respondent. Should be a wide pool.
So my lord, the rate I read there, first and second pools, is that they've lifted those from the grounds of resistance. And the first pool is not a narrow pool.
Right.
Because Vinci is a global company. I mean, it's headquartered in France, but it employs 250,000 people worldwide. So it's all employees of Vinci. All
I
those
see.
who
It's
seek-
not intended to be as employees of Vinci on this contract.
I'm just.
That's
Yeah.
your reading of that.
And then their second pool is. So the first pool is those who are seeking employment, or those seeking work, whether as employees of the respondent or as employees of Vinci. The second pool is all those who are currently employees of Vinci and currently employed of the respondent.
You mean employees of Vinci anywhere?
Well, that's how I read it.
Right.
Yes.
So your reading in that case is not that any of these is the narrow pool. Is that?
That's how I read it. So I believe the first two are taken from the grounds of resistance.
My Lord, I may just say that we agree with that.
Yes, I think it does become a bit clearer if you look at the grounds of resistance. They seem, whether they're good pools is another matter, but one can see the thinking behind them.
Right. So before I stop, is it to be understood then that in the list of issues, which was at the beginning of the hearing and was agreed, nobody was arguing for the narrow pool in the list of issues?
So, my lord, I don't wish to be argumentative,
No.
but you'll see where it references our case in square brackets. We've used quotation marks and reference
Yes.
back. So that's what we wrote on the page, and we lifted it from our pleading.
What you have to say and do say is that is a shorthand for your pleading,
Yes.
and it refers back to your pleading, and you explained yesterday why your pleading shouldn't be read by taking out a single sentence.
Then the thing that bothers me, we only get to pool when we have the PCP, and you work out what the PCP is, and then it's all people. The pool is those people to whom the PCP applies. When I go back to paragraph 4 of the list of issues, and I understand arguments about the middle sentence, the reality is, it seems, that the PCP was a difference between in-house staff, as I think of them, parks employees, and outsourced workers, not outsourced workers on the toilet and cleaning contract with Vinci. Or is that a misreading of 4?
Your reading of 4 is correct, my lord. The difference in question of it's probably relates to how widely the PCP is applied.
Well, that's, I think, possibly a separate question, but I understood, as my lord says, in fact, the definition of the PCP and the definition of the pool are mirror images, or one leads to the other. And your response again is the same. We're back in the same territory as we were yesterday. I think you're saying the list of issues should not be treated as supplanting the pleadings. It's simply a shorthand for everyone's of picking out the things that appear to be an issue from the pleadings.
My lord, yes, that's why you have, or why I think at the time I included in square brackets and bold the reference to the paragraphs in the pleading.
Well, obviously, speaking for myself, I think we probably ought to move on from the list of issues.
Yes.
Thank you.
Yeah.
My lord,
Burden of proof.
burden of proof. So you had here a case where the parties disagreed when it came to the question of how widely was the PCP applied. On our case, we considered the PCP was applied to in-house employees and ourselves, so the people on the cleaning contract. The respondent put forward, as you've seen, multiple pools, but in closing said their pool was in-house employees and workers on other subcontracted workers on working under.
Yeah. So when we are talking about our case, you're really talking about the case by the time it got to closing submissions.
Yes.
Yeah.
So in closing, the respondent's position was in-house workers and whom?
So perhaps I can take you to Mr. O'Dempsey's closing submission, supplemental bundle. I believe it's page 13. And paragraph 53.
It's all outsourced workers, is it?
all of those who work for any of the contractors engaged by the R. And then at paragraph 59, my lords, the final sentence. Therefore,
Well,
the
we ought to
proper
look
pool.
at the first 54, first sentence 54, the pool,
Yes.
pointing out you haven't got any evidence about that pool, should enable the comparison ratio to make up all those who are employed for the R's contractors.
Yes.
Yeah. And then 59,
Yes, it's the final sentence. Therefore, the proper pool to test.
yeah.
Well,
Yes.
I say, when you have parties each putting forward or contending for different pools, as you quite rightly raised yesterday, question is who bears what burden of proving what pool is the correct pool. And we know from the case law that the dicta say in most cases there will only be one logical pool.
Yeah.
Lord, I say that in this case, in a case such as that where there's a dispute, you should apply the ordinary rule of civil evidence, which is he who asserts a fact must prove that fact. So, for example, if claimants are asserting that the PCP was applied to them as a group, the burden's on them to prove it. If the respondent is asserting that PCP was applied more widely and to other subsets of contractors, the burden's on them to prove it. I say that follows not just as a matter of principle, but it also has some practical attraction. 2. Number 1, it ensures that parties put forward credible and focused pools. So the respondent will, before it says Vinci's global workforce or people seeking employees with Vinci should all be in the pool, knowing that it has to prove what it contends for will ensure that a respondent always chooses a focused pool, which it knows it will have to prove. And that's good because it saves everyone time and it gets everyone serious from the go. The second advantage, I say, is it ensures fair play when it comes to disclosure. So an employer can't say the correct pool is all Vinci's workforce or all job applicants for Vinci, or it can't say the correct pool includes people on the landscaping contract, but we're not going to provide you with evidence of the landscaping contract.
Well, it's not quite. The respondent, in a sense, isn't putting forward a pool in the same sense as you are. He is saying conceptually, this would be the right pool if various other things were satisfied. And you then have two choices. One is to say, no, it wouldn't be. And the other is to say, well, as an alternative, it would be, and get the evidence to prove your alternative case.
Yeah.
It's not, the defendant is not in that sense advancing a particular pool. It's not part of his, he doesn't have to prove anything on this. Is that not right?
So, my lord, I would respectfully put it in a different way. If the respondent is saying that it applied this PCP not just to you claimants, but also to other contractors, and they must therefore be brought into consideration. And tribunal, you have to look at other contractors. Then the respondent has to prove that it applied the PCP to those other contractors.
I appreciate I'm like a cracked record on this topic, Mr. Cole, so apologies and do switch off if I sound as if I'm repeating myself. I've just gone back to section 19
Yes.
You're a claimant, what you have to prove.
Yes.
You have to prove that you've been discriminated against. And to do that, you must show that the respondent applies a provision, criterion or practice which is discriminatory in relation to a relevant protected character.
Yeah.
The first thing you have got to do is identify the provision, criterion or practice which you say is discriminatory. Then, if you identify the provision, criterion or practice, you've got to look at little 2 in relation to a protected characteristic. Does it put the claimant at a disadvantage? So the starting point is to identify practice,
Yes.
provision or criteria, and you're doing that because you're showing that practice puts BME people at a disadvantage compared to white people.
Yes.
And the pool is a working out of that, trying to see whether or not it is actually putting people at a disadvantage or not. Because if all the people to whom the protected practice applies are BME anyway, then it's not racially discriminatory. If they're all white, it's not racially discriminatory. So it's not enough, is it, to say what did the respondents say was the pool. The starting point is to go back to say, what did you say with the PCP? And you've got to prove the PCP.
My lord, I hear what you say.
I've said it before, so
yeah,
don't worry
yeah.
about it.
No, I acknowledge what you say. My submission is Section 19 doesn't require a claimant to prove that the PCP was applied universally. If, for example, you had a patchwork quilt scenario where the respondent had 7 contracts, workers under each, and applied this practice to 3 out of 7. It's not a universal practice, but it is still a practice.
It does make me ask myself then, what was the PCP that you identified? You could have said PCP brackets, but not so far as it applies to people outside Section 41 and so on. And the question, we back to what we had yesterday, so don't worry about it. It's really just how we read the pleadings, I think.
Yeah.
Well, I think we are back to where we go. Well, yesterday it is. I understand why my lord comes back to it because it is central. But I think we see, and I speaking myself, I see exactly how you put the burden of proof. Unless you want to develop it further, or my lords want to ask more about it. Yeah.
If I could just round off, my
Yes,
lord.
certainly.
So I say that the other advantage of having the burden of proof that way, operate that way, is encourages what I call fair play in disclosure.
But yes.
Yeah.
So, which means that, as happened in this case, the respondent cannot say there are other documents, we're collating them, or then change its mind and say we're not going to produce them, and then in closing submission say because there's no, you haven't seen the other documents or tested them, you have to take our say so when we assert that we did apply the PCP. So a party can't hold the tribunal to ransom in that way. We say.
You think you're referring here to the sort of thing that's said in paragraph 53 and 54, which we looked at a moment ago in
Yes, my lord.
in
Exactly.
the respondents' submissions.
Yes.
But that you say is an entirely unsatisfactory state of affairs.
My lord, yes. And now, without wishing to be repetitive, I also refer back to the email which I mentioned in my closing submissions.
The weekend email.
My lord, yes. What I say this encourages is that applying basic civil procedure logic, whether it's the ET rules or the CPR, a party has a duty to disclose documents which are relevant to the issues.
Relevant to the pleaded issues.
Yes. And my lord, I say that duty arises regardless of whether the opponent has made an application for specific disclosure or not. That is a duty de rigueur.
You're pushing an open door there.
So, my lord, I say that's how the burden of proof should operate when parties disagree over the width of the pool or the width of the application of the PCP. And now I say, bearing that those principles in mind, this is what happened in our case, and this is why the ET chose a pool which was correct and defensible on the evidence before it. And there are really 2 points here. Number one, ET had to ask itself, what's the correct pool to test the PCP? Now, I'll readily admit, even looking at the list of issues, the parties, even by day one of the trial, were at cross purposes, and the ET sitting in the middle had to make a decision. What's the real nub of the complaint here, and what's the pool that best tests the criterion? And we say this case was really about a respondent and the way in which it set pay for people, whether they're in-house employees or outsourced workers. So the pool would include everyone whose minimum rate of pay the respondent actually set, so, or if you like, for want of a better phrase, effectively set. And we know from the ESOP case, paragraph 41, that the pool should include everyone who stood to be advantaged or disadvantaged by the application of the PCP, but should exclude everyone who would be unaffected by the PCP. So when Mrs. Justice Eadie, with utmost respect to her, said the pool should have included all contract workers, I say that is too broad a statement. It would have been wrong to include in the pool workers on contracts in respect of whom the respondent exercised no control.
But they always exercise control because they always say how much they're prepared to pay. If it's a policy, appears to have been, that they will not pay their contractors, they will not fund their contractors to pay the London living wage, then it extends beyond those, beyond the toilet and cleaning contract.
Oh yes, if, but I say that is not how the evidence read.
Yes. Well, we've been over this. I mean, I think there is an argument, I must say, that the evidence does show that. It doesn't show that any other contractors, you had as extreme a situation as you have here, with the contractor saying, here's two choices.
Yes.
One London living wage and one not. But the question is whether that is the crucial question, if we know, which we apparently do know, that it was Royal Parks' policy not to fund payment of the London living wage, whatever, not to require payment of the London living wage. Is that an important distinction?
My lord, I believe it is. I appreciate we've had this.
I know we did, but there's no harm
From
going over it
Jarvis'
again,
email.
as long as we're still learning new stuff about it.
Could I come into this from a slightly different angle before we move on? Let's suppose we had our time again and we're back at the Employment Tribunal with the sort of discussion that is being had now in our minds. What options did the Employment Tribunal in practice have faced with what you've described, maybe correctly for argument, as cross purposes? May not be that, but suppose you're right, and the situation was unsatisfactory. What were the possible options for a tribunal in that situation? Regardless of the burden of proof, just as case management, we've got to sort this out.
My lord, I say it's exactly that. It would have been a case management decision. Option A, tell the respondent, if you want to run your argument and say other contractors should be in the pool, then I'm going to direct you to disclose evidence of who those other contracts were with and your involvement in the negotiation of the contracts and whether there were two bids and whether you reserved the contractual power, etc. That's option A, and it would have been to basically adjourn and then part heard.
Adjourn for discovery.
Yes.
I mean, normally you'd have had a case management conference. In the old days when I did these things, this would be long before you got to the hearing. There'd have been a special case management conference where you'd have thrashed out the possible PCPs and the consequent pools, and you'd have had directions then. And that didn't happen here, did it?
My lord, as we do the post-mortem of the case.
Okay, anyway, sorry.
Yeah.
So
Sorry, it doesn't matter. Was there, this may not matter, just saying it factually correct. Was there no case management conference, or there was a case management conference at which this problem was not identified
The
without
latter,
triple blame?
my lord.
Yes, I see. Thank you.
That's option A.
Option A. Option B. Say to the respondent. Well, this would be applying the burden of proof. You're arguing this. You don't have any evidence. I'm going to consider your argument without the evidence of other contractors having been provided, and it would have been the burden of proof would have then decisively operated against the respondent.
Right, so tell the respondent that if that doesn't happen, the case goes ahead on the narrow pool.
Yeah.
Before then going ahead. But basically in order to give the respondent the opportunity to apply for an adjournment.
My lord, yes.
Right, and neither of those things happened.
Thank you. Yes. Anything more on burden of proof?
Very briefly, the witness statement, and I appreciate you don't necessarily want to go to this. I've understood, but if I could just give you two references to write down, please.
Mr. Jarvis's witness
Mr.
statement.
Jarvis's witness statement, which is at tab supplementary bundle tab 10. The first reference is paragraph 11.
It's rather half-baked. I think if you
Okay.
are referring to it, we ought to look at it.
My lord, yes. So in the supplemental bundle,
Yes, we got it.
at page 79, at the top of the page you have the subheading outsourcing, and this is where he gives an overview of outsourcing generally. Paragraph 11, he lists there, and I count it to be 7 different functions which were outsourced. Toilet attendance, which is our claimants, landscape maintenance, horticulture, gate locking, building and maintenance repairs, parking, catering, and event management.
Yes.
In none of, he doesn't address what the process was, the contractual negotiation or the bid.
We got that point, yeah.
And then the only other reference I take you to is at page 92. And it's the top of the page, very first sentence, paragraph 89. The Royal Parks did not dictate the pay rates under its outsourced contracts.
So where's that 92?
Page 92,
Okay.
paragraph 89, my lord.
Yes, but that's, to be fair to it, that's its argument
Yeah.
that ultimately Vinci or anyone could have said more. It's not really trying to say here, is it, that for the others, excluding Vinci, it didn't fix the pay.
It talks about contracts, plural, and the next sentence talks about contractors, plural, twice.
Royal Parks did not dictate the pay rates. It did not specify that the contractors paid staff. That's what the point is, isn't it? There's no requirement saying
Yeah.
you fix whatever salary you want, but if you're getting this contract got to pay LLW. That's all it's saying, isn't it?
Yes, my lord, that's exactly the point. That's
right.
the extent of the evidence.
Right.
It did not give alternative evidence and say, oh, and by the way, this is what actually happened in respect of the 6 other contractor blocks.
And does 80 help at all?
80.
90.
90, sorry, yes. My eyesight is going as well. That's a bad sign.
It's always aspirational for TRP to pay each contractors. That's a slip. It means it should have said it was always aspirational for TRP to require its contractors to pay the LLW.
It looks like a slip.
But it's all contractors, isn't it?
Yes.
And it is conscious that LLW could be in legislation. And in 2014, which happens to be when the Vinci one was, but we don't know if others were, they were asked to put forward 2 tenders, one of which sets the pay at LLW. That does rather sound as if it's a general statement.
Well, we're going back over old ground really hard. But your point, why you've taken us to this, is simply to show that the only contracts about which detailed evidence is given is the toilet and cleaning contract.
My lord, yes. And I say, to an extent, the respondent boxed itself in with running a primary case that it didn't dictate any pay rates to any contractors. In closing submissions to the tribunal, it would have said, well, that's our primary case and that's what our sole witness says. But as a secondary case, I invite you to reject that bit of evidence from Mr. Jarvis and find that we did control the pay and reserve a contractual power in respect of other contractors.
No, they were taking an overall point that I might call an Allenby point, that however much economic control or what you call real world control they never had any contractual control, which is correct. It'd be perfectly possible for Vinci, in theory, to accept the lower price, but to pay its employees the London living wage, despite not being funded to do so and despite not being required to do so. They would just have taken a hit on the contract and would have made no profit or less profit. So they weren't telling them not to pay the London living wage. That's not all the point that's being made here. And this is stuff we've gone over yesterday. And you say that that's not the real world.
But also, I say
Mr. Milford will say that's the correct analysis. See Allenby. We'll just have to decide what we think about that. But I don't think there's any inconsistency in their running that argument, the arguments they have to run about pools.
Well, the term your expression contractual control, you'll recall they reserved a contractual right to revisit the hourly rate in the Vinci contract.
I dare say, but until they do, they don't. And anyway, I wouldn't have thought the contractual right to revisit means we require you to pay less than the London living wage. It will mean we require you to pay the London living wage.
Yes.
And then they'll have to fund it. So I don't think that really advances the argument.
Very well, my lord. I won't overreach.
I'm keen to move on. I don't want to stop you saying anything you want to say, and where I know perhaps slowing you down ourselves. But is that all now on burden of proof?
My lord, yes. The only other point I make is that the way of testing that the tribunal here chose a correct and defensible pool on facts is this is a pool which it's not a case like Nelson, which you have in the authorities bundle, where you have a pool of single digit workers, 6 or 8 employees, where courts don't like using small pools because they can give rise to statistical flukes, and they're not necessarily a good measure of whether something has a disparate impact. This is a pool with 210 employees, and this is a pool where the statistical difference was substantial. Well, if I can move on to the issue of why, in my submission, the EAT was wrong to substitute its its decision. I think my Lord Jackson has already preempted this. This was a case where there wasn't simply only one outcome. This is a case where the Employment Tribunal had options, and the EAT in my submission oversteered or overcorrected by substituting its own view. And the EAT's proposed pool, which is that all contractors should have been included, was with respect a flawed pool because it admitted everyone in an unfiltered way, regardless of whether or not they had their pay controlled in the same way. So the EAT's proposed pool would have, in my submission, fallen foul of ESOP paragraph 41. And it would also have fallen foul or risked falling foul of section 23, which says that you can only compare people whose material circumstances are the same.
Can I just be clear about those? I've fully got, because it's where you focused yesterday, on the fact that the EAT's pool is flawed because there was no evidence that the Royal Parks controlled whether or not London living wage was paid. So that's one aspect. Are there other aspects, perhaps this is going to be your fourth heading, in which the pool, the EAT's pool, risked including people to whom the London living wage did not apply, or to whom the PCP did not apply?
My Lord, the other aspect is that pool may have included people who didn't work in London, and that must be a material aspect because we're talking about the London living wage.
So I don't understand that. I thought this is just the Royal Parks in London, or are there Royal Parks outside London?
Well, if the question is contractors, I don't know what the. I think there's some evidence about.
Well, there's evidence about where the Royal Parks are. I think they are
In
all.
paragraph 2 of Mr. Jarvis, that they were the current emanation created in 2017 to manage around 5,000 acres of Royal Park land across London.
Aren't any in Wales?
The whole case is proceeded on the basis that we're dealing with London, isn't it?
Yes, my lord. I think I will have to check whether there was a reference to contractors working outside of the M25. But I don't know whether I
Is the M25 the boundary to the London living wage? Was it Greater London? I don't know. It's not a statutory concept, of course, is it?
You need to be careful too, because if you're not careful, they'll not be in the same material circumstances, because those who are commuting in from Hertford might be in a materially different position, and they may not, in inverted commas, need the London wage, whereas those who are facing the cost of Tesco's in Hammersmith might be facing bigger costs, so be careful about that.
Yes, it was simply the question of where geographically they're based for work.
Well, I'm very personally, I really, this is a point that's never emerged before, as far as I'm aware.
Right.
If you tell me it has, we certainly haven't got the material to resolve it. If it has, I will stand corrected.
Well, my lord, if you permit me, not now to waste the court's time, but to have a look.
Yes,
when I
okay,
can.
come back on it later. But the reason I asked you about this now, and as I say, it may anticipate your final heading, which is material differences, you were saying it was wrong for the EAT to substitute its own view because its own pool was flawed, and the one reason why it's flawed is the one we've explored. I was just wanting to be clear whether you were saying that the EAT's pool is flawed in any other way.
Well, without going over old ground, and the question of the application of the PCP.
Yeah, that point we've got,
Yeah.
but I just want to make sure there's nothing else. No, thank you.
Lords, if I may then address you on my learned friend's additional reason number 2,
Yes.
which raises the issue of material differences. My learned friend raises 3 supposedly material differences. Before I go into the first, he also says in his skeleton, and this is Underhill tab 4, page 49.
Page
49, please, my lord. Paragraph 26, he references the tribunal's finding that the respondent had committed to the LLW as a benchmark for its employees, but then says there's no evidence that such a benchmark had made any difference to what ours employees were paid. Shall I say that's that argument that there was no evidence is not quite right. If you have a look, my lords, in the supplemental bundle at page 25, please. For reference, this is part of closing submissions for trial. Paragraph 18.5, we reference and quoted from evidence which is before the tribunal. And I'll pause to allow you to reread
So
it.
what are we looking at? Para 25?
18.5, please.
18.5. Yes.
So there was evidence from a document written by the Director of Resources at the Royal Parks that they had a system where they used consumer price index to ensure that their in-house employees' pay always remained above the LLW.
It's a little, I'm sure we'll manage, but it's a bit unsatisfactory here, and we've done it again in relation to the weekend email. We haven't actually got the documents, we just got how they were quoted in your closing submissions. It would be a very easy matter to put them into the supplemental bundle. Unless a problem arises, I'm not going to ask for them, but can I just flag that for future reference. But unless we hear any contrary to Mr. Milford, we'll assume that's a fair summary.
I don't quite understand it actually, the problem. This is all about the inflation awards. And there's something in the inflation awards that means the staff receive an increment above inflation and they remain above London living wages.
Well, as I understood it, the starting point is that in 2017, it was clear that it was above London living wage. They made sure that in all pay awards since then, where London living wage goes up with annually with the CPI, so that if the employer doesn't make at least CPI increases for people near the bottom at least, there's a risk that they will fall under.
Right, so the LLW end up on the CPI, and yeah, okay, no, my fault.
Yes.
My lords, there's also the evidence which was given.
These are still rebuttals to what is said in paragraph 26 of Mr. Milford's term.
Yes, my lord.
Okay.
Unless you think that I'm
No,
labouring
well,
for-
fine. No, I just want. Well, no, I want to see what there is. It's quite an important point.
2 paragraphs above, at 18.3. There was evidence in the form of oral evidence from Mr. Jarvis about what would have happened if an employee's pay had, in a marginal case, dipped below the NLW.
Well, again, same point. Normally, if you're going to be relying on something said in oral evidence, which there's no finding about by the tribunal, one would expect to see. We don't obviously have transcripts, but some sort of agreed note. But again, we'll hear. It may well be. It doesn't. Frankly, doesn't sound at all surprising. I'm just a little bit. The purist in me doesn't quite feels a little bit uneasy about all this dipping into the submissions. Anyway, yeah, we see what you say about that.
There is a cross reference which doesn't repeat or record that evidence, but which is at page 116 in the reasons for ET, paragraph 44.
What bundle are we in?
Core bundle, my lord.
On which page did you say? 116.
116, please. Tab 9.
Ah, yes. Well, I remember that. Yes.
This talks
Well, I mean,
like I said, it doesn't.
I think you're probably pushing an open door that it was the policy of Royal Parks to make sure that their directly employed employees were not paid less than the London living wage. The point which you haven't yet got to Mr. Milford's 3 differences. One of them, as I recall, is that none of this really bit in practice because their levels of pay were such that they were always going to be above the London living wage. Now you may say that the points you've just made have slightly chipped away at that, but I think I'd be helped by looking at what his 3 points are and seeing what your answers are.
My lord, yes. His first point is that market rates, and he says in his skeletons at core bundle page 50, paragraph 28.1.
Yes.
The argument here is that, well, the work's completely different and the market
You said
rates.
paragraph 21.
So sorry, 28 sub 1, sub
28
paragraph.
sub 1. Yes.
This is the point about market rates. We say this is not a material difference because the London living wage is a concept which is meant to, in my submission, apply irrespective of market rates. It's not to do with economic value of the work, it's to do with the basic cost of living, and it's the acknowledgement that people living in London are exposed to higher living costs or working in London.
Can we just test this with a more extreme example? Suppose that Royal Parks had adopted a maximal outsourcing, so they outsourced also what I might call the lower level of management, and they were simply left with, might be rather implausible, but a board of quite a workforce of quite senior managers, none of whom is paid less than 50,000 a year. Roughly, what's the London living wage in salary terms? In annual salary, annualized terms?
28.
Doesn't matter, yes. Well, say 50,000 to make it so it's clear blue water between that. Would it make sense to say that Royal Parks applied the London living wage or had a policy to pay the London living wage to that workforce, which was different from its policy of not insisting that its contractors paid the London living wage? That would seem very artificial in that extreme example.
I agree.
So suppose the gap is much narrower, but the rates are never less than 30,000 a year. Presumably, isn't it also artificial to say you're applying the London living wage to a workforce whose salaries are always, by reference to the market, not by reference to some policy, above the London living wage? Isn't that the point that Mr. Milford is making?
Well, I say, if you are an in-house employee at the Royal Parks, you benefit from a safety net, and people at the top will never get anywhere close to the safety net, so it doesn't make a difference, a huge difference, or any difference for them personally. But everyone has the comfort of this minimum, and it's a minimum to which the Royal Parks consciously apply their minds.
This is, I think, in answer to the second point, isn't it, Mr. Milford's second point, which you're just about to come to. But we've moved on to that one, which is, the first one is market rate. The second one is that it's on the same paragraph 28. Which is anyhow, we're way above the market rate. Your point and answer to that is surely the Royal Parks thought it was relevant. They said it.
Yes.
You don't have to do more than that. So for them now to say wasn't relevant doesn't really find their mouth to do that.
Oh yes.
They said we pay our employees at home the London living wage, or much more. But we don't do that away.
Yes.
Yes. I think, truthfully, 1 and 2 are very similar.
Yes.
Yeah.
2 ways of saying similar thing.
And then 3, different bodies set the pay by different processes. That's a different kind of point.
Yes.
What do you say about that?
No, before I leave 2, I appreciate
sorry.
what you say. 1 and 2 are very similar. Could I just highlight that 2 was, so far as I can tell, not the point that was argued below. and the reference there is Core Bundle tab 12, page 101. That's not the right reference, beg your pardon.
186.
Thank you. So, 186, paragraph 43 of the grounds of resistance lists there 5 pleaded material differences.
Sorry.
Beg your pardon, my lord. So, Core Bundle 186,
Yeah. What is what? Is the respondent's grounds of resistance?
yes,
Yeah.
and paragraph 43 needs 5 material differences. And the argument that
Yeah. Well, 1 and
civil
2
service-
are the same as what we've been calling 3. Maybe
Yeah.
maybe there are other different sorts of differences, aren't there?
Yes.
Yeah.
You presumably would encourage us to remember paragraph 70 of the Employment Tribunal decision, which says the evidence was that the Living Wage Foundation considers the minimum that a person working in London needs to meet his or her basic living costs was the LLW. That applies to all persons regardless of the nature of the work. And then you remind us, presumably paragraph 90, that we accepted that that was something that the ET could reach. That the reasons for taking payment of the LLW applied equally to those in the public and private sector and to those carrying out office based on manual jobs. You see, given those 2 findings,
Yeah.
we ought to be very careful about sticking our oar in and come to different findings. You put it more elegantly, but that's what you would put.
My lord, yes. I say the LLW is a the economic value or the market rate is the LLW is a measure
job.
or a standard irrespective.
It's the person's needs, living
Yeah.
needs, if you like. Yeah.
My lord, then to finish off with the third supposedly material difference, that different bodies set the pay. Well, here we kind of come full circle to
You're
who
right
set the
on
pay.
your other points.
Yeah.
That's not the case.
If they're right on that, hang on. No, this is not the point about Vinci and other contractors, it's just Vinci and it's their main scheme, with nothing to do with ESCO, yes. Mm. Yeah.
My lords, this before I sit down, perhaps everything, of course, on what this court orders depends on what view it takes on the various arguments. What I invite this court briefly to do is, our primary case is the tribunal reached the correct outcome on the facts and the evidence. And I invite you to restore its decision. Our secondary point is, even if you found that the ET took technically a wrong route when responding, the outcome would have been the same. So again, I invite you to restore its decision. And my third point is, only if you find that the ET committed an error of law which materially altered the outcome, then in that case, should you remit to the Employment Tribunal. And the reason why, respectfully, you should remit rather than uphold the EAT's decision to substitute is because this is a case where there was plainly more than one possible outcome.
Which by definition needs further evidence.
And
Because on at least further findings, perhaps. The EAT's position was we don't need to send it back because on the findings made, there is only one outcome. Yeah, okay.
and is there a normal practice, in other words, we'll know, as to sending back to the EAT or sending back to the
It would have to be to the ET.
It would have to be to the ET.
But I was thank you for your patience, for putting up with me.
No, your submissions have been very thoughtful and well presented. Thank you. Yes, Mr. Milton.
Thank you, my lord. With your lordship's permission, what I propose to do is to start with our response to the appeal and then go on to the respondent's notice and to deal with that in the order in which it's dealt with in my skeleton. So first of all, to deal
Whatever works best for you, Mr. Milton.
as long as you're happy with that. my lord. So let me start, if I may, with the response to the appeal. And we say a useful starting point is just to bring this back to the Employment Tribunal judgment to remind oneself of what the Employment Tribunal actually found on the formulation of the PCP to which this appeal relates, which was the one that was urged on it by the claimants. So that's paragraph 68 of the judgment, Core Bible tab 9, page 121. And the last sentence, it's clear to us that TRP applied provision, criterion or practice to the claimants that its employees would be paid the LLW as a minimum wage, but those working on the cleaning contract with Vinci would not be paid LLW as a minimum wage. So that's the PCP that the tribunal applied. And we say that PCP was an error of law because the tribunal jammed together two different things and wrongly characterised them as a unified PCP. On the one hand, a policy of paying employees the London living wage, and on the other, a practice of not requiring payment of the London living wage for workers on the Vinci contract, which resulted from a particular decision on that contract in 2014. And on its face, my lords, it's not a single unified PCP at all. It's expressly framed, as the EAT pointed out, to be bi-directional, using Mrs. Justice Eadie's word. And
Would it have made a material difference though if the PCP had simply been not to fund payment of the London living wage to outsourced contractors?
yes, my lord, and I'm going to come to that.
Okay, all right, thank you.
Or a policy of paying LLW for employees, but not for those contracted workers whose wage they effectively determine, which might be only Vinci.
Well, my lord, I'll come to that as well. Yes,
Okay,
the
we'll let
various
you
different ways
get
in
on.
which
Yeah.
it might have been put. But as it was put, we say that it was obviously erroneous because it was two separate PCPs requiring two different comparative assessments. The first PCP, employees get the LLW, related to the payment of LLW to employees and logically required a comparison between directly employed persons and outsourced workers generally. And the second bit of it, those working on the cleaning contract with Vinci won't be paid LLW as a minimum wage. To the extent that that was a practice in terms of reflecting the way in which things were generally done, we say that the logic would be that in your disadvantaged bucket of Vinci workers and in your advantaged bucket is everyone else, including other outsourced contract workers. So that's the problem with the bidirectional.
But hang on. Are you saying it's not a valid PCP at all, or are you saying that if it is what you call bidirectional, then you've got to have everybody in from both groups? I understand the second. Not sure I understand the first.
I'm saying it's not a valid PCP because it is bidirectional and it requires two different comparative assessments without the ET realising that that's what it actually did.
One different comparative assessment, doesn't it, between the PCP. If you, the PCP affects the whole pool. This is ignoring a different argument we're going to have later about material difference. The PCP affects the whole pool. Our policy is not to pay the LLW, or not to require the payment of the LLW to outsourced to employees of outsourced contractors. Now, in order to have an indirect discrimination case, you've got to say that puts them at a particular disadvantage compared with who? And that is surely compared with people to whom the PCP is not applied. Isn't that right?
Yes.
And so then you look, well, which people are they? Well, that's their directly employed workforce. So you've got a pool comprising the outsourced and the employed. And then you see whether it has a disparate impact on racial grounds as between within the pool.
I'm sorry, my lord, I may not have explained myself very well.
I may be muddling myself, so it's not, these things are never easy.
What my lord has just put to me is exactly what we say the position is on the PCP. We will only pay LLW for our employees. And we entirely agree with my lord that the pool for that is employees and outsourced workers, with employees being advantaged and outsourced workers being disadvantaged. The point that I was seeking to make, probably rather unclearly, was a slightly different one, which is that by formulating the PCP, supposed PCP, in the way that it did at the end of paragraph 68, the tribunal was forcing together two different PCPs, the first one of which was exactly the one that my lord has put to me. Its employees would be paid the LLW as a minimum wage. And the logic of that is that the pool is employees and outsourced workers, with outsourced workers being disadvantaged. And the second is actually a separate thing. Those working on the cleaning contract with Vinci would not be paid LLW as a minimum wage. And to the extent that that is a PCP, provision, criterion, or practice, which reflects the way things generally are done, then one has logically to ask, well, who is advantaged in that analysis? And logically, looking at it from an Allenby perspective, it's everyone else.
That's the flaw, if I may say so. It may be the flaw, because the problem is, I thought that yesterday, it's the respondents' workers and all the other outsourced workers. But the other outsourced workers may still not be getting the London living wage, but it may be nothing to do with the parks. Or alternatively, they may be getting the London living wage, but that too may be nothing to do with the parks, because the parks don't have a requirement for anyone that the London living wage be paid. It may be a good employer who just pays it. So the problem isn't binary, whatever the Latin jargon is.
Yes.
You either get it or you don't. So if you've got a PCP where one group gets it, if one group doesn't get it, everybody else must automatically be put in the group that gets it. You need further vital pieces of information. Do they get it? If they do or if they don't, why? And that's Mr.
Yes.
Khan's point about the fixing of it. Sorry.
Yes, my lord, and that comes back to exactly the point about evidence and burden of proof that my lords were discussing with Mr. Khan this morning, which I will be addressing in due course.
Is there a distinction when one's considering what a PCP is? Is a PCP which says that we pay our own employees the London living wage? That's a PCP. Is there any difference in the context of this case? We only pay our own employees the London living wage. Because that is the PCP with which we're concerned, isn't it? I mean, I just want to check what you're saying. Are you saying that one PCP is we pay our employees the London living wage, and a separate PCP is what we do to other people? Because surely the PCP in this case is a united one, namely, we only pay, we regret it, but we only pay our own employees the London living wage. Isn't that what we're doing here?
My lord, well, I think one is then getting into the different ways in which the PCP might have been formulated. I mean, the PCP might have been formulated as a guarantee PCP. So it might have been said, well, we only guarantee payment of the London living wage for our own employees.
Yes, I'm concerned with the word,
but that was not what actually was pleaded. So,
well, hang on. I don't understand the point you're making. I mean, they do guarantee payment of the London living wage to their direct employees. And although the word guarantee isn't used, the effect of the PCP as regards the outsourced employees is they don't guarantee it in the sense of requiring the contractors to pay it.
Yes.
So
sorry,
I don't
my
think
lord, I may have
guarantee
answered that
doesn't
wrong.
really alter the analysis.
I may have answered your question the wrong way around. It said the way in which this PCP at the end of paragraph 68, I call it a PCP for shorthand, although I say it's two of them, is formulated, does have in the first bit of it is, as it were, a sort of guarantee for your own employees. The second bit of it is a rather different thing because it says...
I'm having difficulty with this,
yes.
as you can tell. I quite understand the difference between the Vinci employees and all your outsourced workers. That's a separate matter. But if you're trying to chop up your PCP by saying one is relating to our employees and a completely different one is relating to other people, then I do have difficulty with that because it seems to me that what they're saying in paragraph 68 could have been said in a different way, namely that we pay LLW, guarantee LLW only to our own employees. We have,
Yes.
now, if you take issue with that, you may be right, but at the moment, I don't think you are.
No, I'm not taking issue with that, my lord. What I'm saying on that is that one would have a different pool.
Yes,
That being the
I
PCP.
follow the argument that we'll now get to. Yeah.
I think you were saying that the real vice of 68, when you analyse it, is that what they've done is left out of account a vital group of people, the other contract workers. You do need to know where they go. I cavil at whether they all go in the advantage box or whether some of them go into the disadvantage box or whether some of them are left out altogether because the contracting processes are different. But when you've got two subsets of humans, employed and contract, you do need to know which bits of the contract workers you include and simply saying we're stopping at Da Vinci, you submit, I imagine, is wrong. One, because of the pleading point, and two, because of the logic point. The logic is, although we accept that there might be different evidence about the contracting process, is they are not pushing people to contract on the London living wage.
My lord, you've anticipated my argument, and that is exactly what we say. Yes. So, my lords, just to pick up again my sort of overall response to the appeal, which I was addressing, that we say is the logical result of what the ET actually applied as the PCP. But what is now being put to my lords on appeal is a rather different point, because what's said to you now is, well, there's no evidence that the respondent exercised control over the terms and conditions of outsourced workers apart from those on the Vinci contract, and therefore the pool for consideration of the PCP should be constructed on the assumption that the only outsourced workers within it are Vinci contract workers. And tacitly, that is an invitation to apply the PCP as originally pleaded, i.e. just as a guarantee or two-tier practice as between employees and outsourced workers, but to adjust the pool on the basis that only Vinci workers should be within it on the evidence. And we say the problem with that approach is that it's not the way the case was argued before the tribunal. And it also relies on an assumption for which there was no evidence that the respondent treated other contract workers differently from the way in which it treated Vinci contract workers. And that wasn't the case that was put before the tribunal. And the tribunal couldn't have and didn't conclude that other contract workers were treated differently from Vinci workers. It just didn't address them at all. And if the claimants had wanted to say, although this PCP may logically, see Allenby, require a comparison between outsourced workers and employees generally, in fact, the proper pool is only employees and Vinci contract workers, they would have needed to make that out on the evidence. They would have needed to explain and put forward evidence to make the case that although the logic was the wider pool, actually the evidence mandated a smaller pool. And that wasn't what was done or attempted to be done. So that's my answer to that case now being made. So, my lords, that's our response in a nutshell. And what I propose to do is to set out the principles that we say apply to the concept and therefore formulation of a PCP and the construction of appropriate pool, then look at the way that the claim was pleaded and argued, and then look at the tribunal's reasoning and the errors it made. But and finally address you on the grounds of appeal. But I suspect I can be very short on a lot of those topics because my lords have covered so much of the ground. On legal principle, we do say it may be just useful to turn up the relevant bits of the authorities that we say underpin conclusions that ought to be reached here. And the first is Scholar, which is tab 26. So that was a case actually about reasonable adjustments, so sections 20 and 21. But the central point was about what is the meaning of a PCP. and the claimant appealed on the basis that the tribunal had applied too narrow and technical approach to what a PCP was, and EAT and Court of Appeal dismissed the claimant's appeal. Just picking it up at 478, one sees the point there made in paragraph 27, that PCP must mean the same thing in relation to different ways in which unlawful disability discrimination can occur. So equally applicable to section 19, obviously. And then the core reasoning that we rely upon is the reasoning at paragraphs 35 to 38. First of all, that provision, criterion, and practice are ordinary English words that to be narrowly construed, but they're not simply acts or decisions, and a practice must be more than just a one-off thing that would not be done in the same way in future. Then 36, the point is made that what's required to be justified is not disadvantage, but the PCP, in consequence of which the disadvantages suffer. And I just pause there to note that that is the answer to the claimant's submission made in their skeleton, but not to the same extent before you in Mr. Khan's submissions, that really all they were interested in was the particular disadvantage they'd suffered. And paragraph 38 is...
Sorry, just give me the reference in the claimant skeleton. I don't want to look at now, but just my note. Which
yes.
I didn't quite recognise the argument you're making, argument you're answering.
Yes. It's ground of appeal 1. Paragraph 21, they had no reason or motive to overreach and investigate other contracts.
Exactly.
Their focus was yes.
Okay, thank you.
And then paragraph 38 of the Ishola is all three words, provision, criterion, and practice, carry the connotation of a state of affairs, whether framed positively or negatively and however informal, indicating how similar cases are generally treated or how a similar case would be treated if it occurred again. And it seems to me that practice here connotes some form of continuum, in the sense that it's the way in which things generally are or will be done, even if it's not necessary for it to be applied to anyone else in fact.
Well,
So,
that's go on.
That's Ishola.
Yeah, I mean, those are interesting points clearly made by the Justice Similar. But the possible exception of the point you noted as you went along, they don't really bear on any issue before us, do they?
They bear on the question of what would be the logical pull for the second part of the PCP
Okay.
in paragraph 68.
Thank
you. And then the other principal relevant authority is, of course, Allenby in the Court of Appeal at tab 8. And obviously I'm going to come back to that later in the context of the contract workers. But for present purposes, it's just the dictum of Lord Justice Sedley about the appropriate construction of the pool that I rely upon, which arose in Allenby in the context of the indirect sex discrimination claim. And the reasoning for that starts at paragraph 11, page 64. And one sees at paragraph 12, the point made it's for the applicant to identify the requirement or condition which she seeks to impugn. The PCP there being you had to be in prior salaried employment not to be dismissed. But then the nub of the point for present purposes is under the heading differential impact at paragraph 17, page 66.
Paragraph 12, actually, or the second part. If the applicant can realistically identify a requirement or condition capable of supporting her case,
Yes.
say here they and it's a pleading point, but say we were satisfied that the condition was that they would pay LLW to their own staff, but not to Vinci, and that was realistic because there may well be other reasons why other outsourced workers are not in that same group. Why isn't, if they've done that, why isn't that the starting point?
Well, my lord, that does come back to the bi-directional point that I've already made.
It's what you've already said.
It's what I've already
you
said.
just can't, because
You've just-
you're leaving people. It's got to be realistic, and it's not realistic. Leave out of account
Yes.
on one side of the equation or the other a huge chunk of people in a similar situation.
Yes.
Okay.
And then at 17, as often happens, once the condition or requirement is identified, the pool within which its impact has to be gauged falls into place. It's then explained how that was applied in this case. And then further down in paragraph 18, as the Appeal Tribunal's excellent analysis of the possible pool shows, once the impugn requirement or condition has been defined, there's likely to be only one pool which serves to test its effect. I would prefer to characterise the identification of the pool as a matter neither of discretion nor of fact-finding, but of logic. And that's the critical point, we say. And in other words, once you've decided what your PCP is, that itself defines and delimits the pool within which it falls to be applied.
Do Gage, Jay, and Ward and Jay say anything else, or just about your Justice Sedley?
On this issue, I think I'm right in saying it is Lord Justice Sedley. It may also be that it's worth pointing out that this has been picked up and approved by Lady Hale in Aesop. The principle that the identification of the proper pool is a matter of logic. And rather than take you to it, perhaps I can just give you the reference to Lady Hale, which is paragraph 40 of Aesop, tab 23 of your authorities, page 389. So, my lords, those we say are the principles, and what I would now do is just apply them to the facts here, and I think I ought to start with the pleadings, but I'll do that very briefly given the extensive references yesterday and this morning. So, starting point is grounds of complaint at Core Bundle tab 10, page 137. And paragraph 2, one sees that the point about outsourced workers is put generally, and the natural reading of that would be the arrangements apply to outsourced workers, and the claimants themselves are an example of those arrangements. Then you've got the PCPs pleaded at paragraph 12 on page 139.
What was the first paragraph you gave us?
Paragraph 2, my lord.
Thank you.
And the relevant one being 12A, and one can see that it's formulated as a double standard depending on whether staff are direct employees or outsourced workers. Now, my learned friend placed weight yesterday on the phrase up until 11th of December 2019, but we say that doesn't assist in demonstrating that this should objectively be read as a PCP applied only to the claimants. Now, it's true that 11th of December was the date when it was decided that the claimants should be paid the London living wage, but it would also logically be the date from which a general PCP was no longer applied, because the decision made on the 11th of December showed it.
Do we know if anyone was actually paid, an outsourced worker was actually paid prior to the 11th of December 2019? We've seen reference to a policy being decided to do it as contracts changed, and that policy I think was about September 2019, but this may well have been the first time it happened, and I just don't know. Come back after lunch. Yeah.
Yes, Yes, thank you, my lord.
You see the point there?
I see the point. Then paragraph 13A, we say, puts the point beyond doubt that this was pleaded as a general PCP which applied to all employees and outsourced workers, because that's exactly what the paragraph says. Pool for comparison consists of all the respondents' directly and indirectly employed staff.
You say that's right.
I say that's right on
Right,
the PCP.
so
Yes.
Can you, I know you'll come to this when you're doing the pleadings, but can you just give us a glimpse as to how then it came that that wasn't simply agreed
Well,
and everybody got on with it? And how did we get to a list of issues of the sort that we were scratching our heads over earlier on?
my lord, I'm afraid that I can't. What I can't do is explain why it wasn't simply agreed. I mean, I'll
You weren't
because I wasn't there.
instructed. You weren't instructed,
but
you know.
I wasn't instructed below. I mean, what's happened, and we'll come to that come to this. It's paragraphs 48 to 50 of the respondents' pleadings. Is various alternative pools put forward, one of which, paragraph 49, looks like this wider pool, and the other two of which are different.
Yeah.
But in fact, I fully accept that if the respondent had looked at it logically, this is the logical pool. Yes, and so, I mean, no doubt there might have been issues about proving that such a minimum pay PCP existed and had been applied to outsourced workers, but as pleaded, it is a single coherent PCP with a logical pool, and I fully accept that. Then if one looks at the defence at tab 12, perhaps the starting point is 179, paragraphs 10 to 12. Because that indicates, and it's really an answer to a point that my learned friend made yesterday about, they didn't know that the PCP was applied any more widely than them. Paragraphs 10 to 12 make clear that there are lots of outsourced contracts and 7 functions which are outsourced. So,
Well, I'm not sure it does meet. I mean, it's important and interesting, but it doesn't actually meet Mr. Khan's point, because it simply says that they were outsourced. It doesn't say anything about the terms on which they were outsourced.
no, and that's true, my lord. I think what it does seem to do at this stage is to indicate that the respondent understood that this case actually was about a wider issue, at least on the pleading, was understood that the case was about a wider issue than just the Vinci cleaning contract, and that there were other contracts which would logically be part of the background, and these are all those outsourced contracts.
But it's sort of, as you well know, not a native of this parish, but it does seem odd that I appreciate you're meeting the case you're presented with. But in a sense, at this point, one wouldn't, if one looked at the effect of the PCP generally, as we say it ought to be, doesn't in the least have the appearance that arises if one simply looks at the Vinci contract in isolation. You say you're not required to do that, do you? You can run the point, but you're not required to make it good.
Well, I mean, it comes back, I think, to the point that the identification of the pool is a matter of logic. So in a sense, I mean, if we are, we may put forward some illogical pools ourselves, but ultimately...
No, but well, following through at the moment, the fact that you reached a point of agreement, namely that there was a wide pool, and we know what it was. In a sense, at this point, one would love to know what the actuality is here, and whether
Yes,
and only you are in a position to say.
my lord, I accept that. And in fact, one sees from footnote 1 at the bottom of page 179 further details of the other organisations who undertook the functions outsourced by the contracts will be provided. But in fact, I don't understand that they were. And how?
I crossed a page and I haven't followed the footnote through. It's the bottom of the next page, isn't it?
Yeah.
Paper is sometimes better.
Well, certainly, I'll get it off my chest now, and I'm really grateful to those who prepare both electronic and paper bundles, but the bundles in this case hold the record in my experience for dissonance between paper. I think I'm having to add or subtract 17 every time you give me a page reference.
It's very sorry, my lord. I hadn't realised. I mean,
extremely moderate in not mentioning, sort of thing I make a great fuss about at the very beginning.
Yes, if it was 17 in relation to all the bundles, I'd be quiet. But it's different. Anyhow, but can you just give your answer to the fact? Are you just, in a sense, able to say, well, we're responding to this. We have to deal with the case. We're not on putting forward a positive case.
my lord, I don't think I can say anything else than that because I don't know. And I suspect it would be extremely difficult to reconstruct why this disclosure or information provision happened as it did. I mean,
It doesn't
all the
look
time.
in this case. I mean, there may be some cases where it would be a complete nightmare to have to produce data in relation to 350 contracts or something. But in this case, it seems as if you were actually willing to provide the information, although what you weren't taken up on it.
The bizarre thing is, I mean, I still, again, go back to another cracked record. I've got 2 records that are cracked here that I play repeatedly. I mean, there should have been a PC. They wouldn't have had any difficulty getting an order, say, you must give the information, given that you've said you're going to. It's just a missing stage. People just, and it's not a criticism, we've all been there. People didn't just work out the logic of where they were going. They didn't start with the Act, work out the PCP in the pool and say, right, this is the information we need.
Well, yes. I mean, the oddity is, this bit of the pleading is, I fully accept odd in terms of what then happened. But actually also, the claimants themselves seem to recognise at one stage, and I'll take you to the relevant letter, that they would be asking for further information, and that never actually happened.
But in a sense, with a claim of this sort, the employees that are before the tribunal are, on any view, your least advantaged employees, or I call them employees without knowing that they're not. But in a sense of your team,
Yes.
whose work you appreciate, they're your least advantaged individuals. And so in a sense, what's happened here is that you've been, you would say, unfairly dealt with by the wrong pool in the Employment Tribunal. And now we've reached a situation where the pendulum swung right the other way.
I recognise that, my lord. I mean, I must say that they were, and obviously had been, very competently represented by solicitors and counsel. So from that point of view, the forensic disadvantage perhaps doesn't really exist. But yes, I have to accept that.
Yes, and I also, in saying this, I do appreciate that you're a charity and that you wish to be paying the London living wage to anybody who does work for you. I understand that.
The responsible doesn't say who prepared it, whether it was an in-house employee, an in-house lawyer, a solicitor or counsel. Do we know anything about who prepared the response form? Not a name,
I
but
think it was insurance-backed solicitors, my lord.
so it would have been legal input then.
There would have. There would
must,
certainly
sure,
be
yeah.
legal input.
Yes, but well, you can't say whether it's.
Yes.
Can I just come back to the point my lord was putting in? This is the point to some extent about where the burden lies, which I was exploring with Mr. Khan. He clearly has to plead the pool on which he relies and produce the evidence in support of that being the correct pool. And if necessary, and if there's any material that has to be, he can only do that with the benefit of disclosure. He has to pursue the necessary disclosure. And if you say that is the wrong pool, the logic of your position is that the pool should be X. I put to him that he's got to take a view on that. He's either got to deny that it is or plead that case instead or in the alternative, and again plead the facts on which he relies. And he said, well, it's not as simple as that, because your case that it's the wrong pool depends on certain facts. It depends on whether you actually applied the PCP to a wider group of people than the ones that it now appears he was actually wanting to base his pool on. You do need to plead in those circumstances, don't you, and prove, no, your pool is wrong because I actually applied exactly the same policy to gardeners and security people and perhaps concessionaires, that they may be a bit different. You can't, and that means you have got to say, I did not insist on paying them the London living wage either.
My lord, I'll come back to that point fully when I deal with burden of proof, but I think that the short answer to that, it seems to me, is that the burden always remains on the claimant to prove disparate impact within an appropriate pool. If they have pleaded a logical PCP and a logical pool, the burden is on them to show that the PCP is applied and there's, if notwithstanding that logic, the respondent says, no, it should be something different. You should exclude groups X, Y, and Z from it, or include groups A, B, and C, then it is indeed up to the respondent to plead and prove that case on the usual principle that he who asserts must prove. But that is within an overall framework where the burden on this issue is the claimant's.
I see that. And of course, a complication here is that it's not a case where they pleaded a narrow pool and you were arguing for a wider pool, in which case, as I think you've just conceded, you would have to plead at least the facts that said the wider pool was the right one. They were themselves pleading, apparently on a literal reading, the wider pool. So it wasn't up to you to prove anything. It was simply up to you possibly to give disclosure on points relevant to that pool, like what the ethnic breakdown was, which you didn't do, but then they didn't pursue it because although they were pleading one thing, they were actually thinking another. And all this never emerged until the hearing.
But actually on ethnic breakdown, my lord, it may be just worth thinking about a further point, which is that they could have asked for information about that, but did not do so. But actually, in terms of disclosure, I'm not sure that that is something that would have been within our, would have been.
No, well, of course, this is a problem that, in theory, there could have been third party. There could have been an application for third party disclosure, which I think the Employment Tribunal has power to order. Yes. But they would have pursued it with somebody.
Part of the problem in this case, firstly, it's hindsight. Secondly, by the time you get to round 3, you're just focusing on one bit of the case. And the difficulty is, one of the reasons we now think that there might, in inverted commas, be a problem with the pool of all or some outsourced workers is that we spend such a lot of time worrying ourselves to death about Section 41. And it's only when you're trying to get lots of people out on the lifeboat of Section 41 on the grounds that you don't fix the terms. But we now think, or people have said that you did fix the terms for Vinci, and then we're turning that debate into all sorts of caveats and qualifications on the pool. And it's very hard to keep a handle on what was happening when there were a lot of moving parts. And I'm busy poking one part now, and I wonder whether that's really what the case was actually about when it started.
Well, it was about all those things, my lord, and I think it was understood to be about all those things. But it's also important to keep the section, sort of, not to let the analysis of one bit lead into the other. Yeah. My lord, I was just taking you to. We were just dealing with the respondents, or about to deal with the respondents' pleaded case, but I think I probably don't need to take you to that. I mean, the essential point is we pleaded a variety of different pools, one which appeared to be the correct wider pool.
Well, could we just go finally back to that, because it's
yes. So that is 116. Sorry, I'm so sorry.
Are you talking about the list of issues here? Or?
No, I'm talking about the response, and the response, the relevant bit of the response is at paragraphs 48 to 50, which is page 187 of the full handbook.
Yes.
So paragraph 48, as Mr. Khan said earlier, and I entirely agree with, is pleading a sort of not the pool that the tribunal eventually adopted, but a pool which focuses upon Vinci but looks at those who are seeking work, whether as employees of the respondent or as employees of Vinci, or all employees of Vinci and employees of the respondent.
What was the distinction between seeking work and being an employee?
My lord,
I'm guessing.
I'm not going to seek to defend.
No, but
these
can you even tell
pools.
us what the thinking was? I'm wondering whether A was directed at 41(1)(a) because it's about the terms on which you're allowed. There must maybe understood which you're allowed to work.
That may be right.
And that B was directed at D, which is any other detriment. If it's not that, I have no idea what it is.
I think I'm in the same position as my lord, and I'm
No.
sorry as I can't help him.
It's
No,
all-
it's frank.
See why
which is helpful.
all the employees of Vinci, as well, given that we're told it's this massive organisation based in France that have got people everywhere. It's not easy to see what the relevance is of a gamekeeper in Scotland, or if they've got a gamekeeper.
Then 49 appears to be possibly with some qualification, but appears to be the pool that is actually urged by the claimants. Anyone who's employed by an organisation which provides a service to the respondent, I mean, that seems to be an employee versus contract worker point being made there. And paragraph 50 simply makes the sort of responsive point, no logical reason to restrict the pool for comparison to those employed by Vinci who work on the functions which were outsourced by the contracts. Now, I mean, it's a responsive point to a point that wasn't at that stage actually being made in the grounds of claim, but nevertheless, I say it's right.
I mean, para 48 is odd in a way. The first sentence is odd because looking at the pleading and at how you appear to have understood the pleading at some points, they weren't saying that. So why say they can't say that?
Exactly.
But there must have been some indications that they were actually thinking of saying that, or maybe it's just defensive pleading.
I mean, I've certainly
Yes.
it's not been suggested to me in any course of my involvement with the case, either here or in the EAT, that at this point that suggestion had been made.
At this point, it was purely a response to the pleading. And
Yes, okay, so just as a final question on 48, insofar as one can understand what's meant by A and B, is it the case that as we sit here now, or stand here now, neither of those could be defended as being a proper pool?
That is the case, my lord, yes.
I mean, in other words, everybody working for Vinci in the world or seeking to work for Vinci in the world is completely irrelevant to the dispute in question. So having got to the point where everybody seemed to have, at least on paper, agreed to the same pool, then the discussion goes off in all manner of directions, including ones that couldn't possibly be a logical pool, and the ET is left to...
Well, no, my lord, not when it gets to the ET actually deciding this issue. When the ET decides this issue, counsel and the respondent
things
is
have
putting their
narrowed right
case.
down.
Yes.
Yes.
Yeah.
Yes. So, my lord, that's the pleadings. In fact, if one looks at paragraph 6 of the pleadings, it asks for further and better particulars.
Pleadings, you know, in the response. Or?
Sorry, the response, yes, page 177, asks for further particulars, and those were provided, and they are at page 1 of the supplemental bundle. And this letter makes clear that the claimant's case remained as pleaded at paragraphs 12 and 13 of the grounds of complaint. And one sees that from the underlined bit, paragraph 5 of the grounds of resistance, just by the second hole punch. So, and this paragraph is interesting insofar as it indicates that the claimants were going for the wider PCP and also saying the contractual processes by which this double standard came about are known to your client and a matter for evidence. We invite you to be completely transparent.
So sorry, where are you reading from?
Sorry, this is bottom of page 1, supplemental bundle.
Do we have the order of the 1st of April in the bundle? I couldn't see it.
No.
Could we have it for good order's sake? I imagine it simply gathers up the requests made in the course of the grounds of resistance. But I think...
Yes.
Yeah.
And then...
Yes, in fact... Perhaps this is what you said. Although para 6 of page 177 has been highlighted, the key FBPs are in response to the request in para 5, which hasn't been highlighted.
Yes, I'm so sorry, my lord. I think I gave you the wrong paragraph then on page 1.
It doesn't matter, but
Yes. And then if one turns over the page and has a look at that, paragraph 6 of GOR, matter relied on for the assertion that the circumstances are materially the same as those employed by the respondent.
So I'm just not with you. Where are you? Paragraph 6 of what now?
Paragraph 6, I'm so sorry, this is the
I was last on
supplemental bundle,
SB1.
Supplemental bundle, page 1.
yes, I think you mean para 6 of that. It's not actually para 6
No,
of the
I'm
letter.
quite-
The heading.
The heading is paragraph 6, so I can see paragraph 9. I'm so
Yes.
sorry, yes.
Yes. The claimant's case on disparate impact remains as set out at paragraph 13 of their grounds of complaint. In response to your specific matters, the pool for comparison consists of the respondent's directly and indirectly employed staff. The respondent knows the names and identities of all its in-house staff, both white and BAME. So that response to the request for further information sort of doubles down on the generality of the pleading
Yes, though admittedly in a different context.
in a different context.
C is interesting. The issue is not individual salaries, but the policy. What's that answering?
I see. It's answering, assuming it is a direct response, it's answering the pay and rate of pay which it's alleged applies to any alleged comparators.
Right, so it is actually.
Anyway, we can follow all that through to the extent that we need to.
Yes. So that's where the matter remained up to trial, and my learned friend Mr. Khan has taken you this morning to his opening note in the list of issues, which effectively reflect the pleadings.
Yes.
Those don't alter the position. But what does obviously change is what the tribunal is eventually asked to do at trial in the course of closing, which one can see from the tribunal's judgment itself, tab 9, page 101, paragraph 2. And that's where it starts, and one sees at paragraph 3 the claimants then saying that actually one needs to look at the grounds of complaint as a whole, and really the complaint is just about Vinci contract workers, and that's therefore who should be in the pool and how the PCP should be understood.
Could you just give the page reference again, please?
Yes, my lord, it's 101.
Yes, you're reading from.
The core bundle.
Para 3.
The core bundle.
Right,
So
okay,
this is
so
the tribunal's judgment.
The core. And it's 101.
101. It may be that my lords just want to read paragraphs 2 to 5 just to remind ourselves of where this got to.
This is the point in the BT decision where this issue of what the claimant's case was is dealt with, is it?
Yes.
So where they're just identifying the complaint.
Yes.
They're not considering the logic.
No.
Yeah. Thank you.
And that's a question of construction of the document, presumably, which is a part of law. And
Yes.
And that's see exactly how they did it. The arguments are very much the arguments we have heard from Mr. Khan, and we're not about to hear from you unless you want to adopt them. And they went with Mr. Khan rather than with you, or not you. Yes, you. No, Mr. Dempsey. Yep.
Yes.
Yes, and you don't disagree with how this emerged. You weren't there, but your trusted solicitor was there. But
The client is sitting behind me, my lord.
right, it emerged. We were told basically on day 3, and was crystallised in closing submissions prepared overnight and developed orally.
Yes.
I mean, deeply unsatisfactory way for the main point of the case to emerge after all the evidence, but that's how it was.
Yes. I mean,
Not unknown, particularly, of course, in indirect discrimination cases, which are notoriously tricky.
yes. Yes. Now, there's perhaps one more sort of piece of the jigsaw that I ought to take you to, which is the reference that my learned friend took you to yesterday at supplemental bundle page 23
Yes.
to
Weekend
the
letter.
email, 20th of August 2021. So the sort of the Friday night email, as it were,
Yes.
at the bottom of the page, paragraph 12.2.
Yes.
Now, I'm obviously in a certain amount of difficulty about that because I don't know what the thinking was there, but I accept that the email says what it says. I don't know whether it was written in circumstances in which, in fact, it had already become clear that the claimants were going to be arguing for a narrow pool or not, because
Well, on Mr. Khan's account, not. Mr. Khan's account, this emerged on the Monday, this issue, if I've understood that correctly. Would,
that may be
do-
similar.
do
I
you
don't
both
want
have
to
the
say
full-
anything about
yes,
it.
okay.
because
Do you, I know, I don't want to put you in a difficult position. Do you both have the full email? Or either of you?
I can get hold of the full email, my lord. So yeah, I don't have it here, but I can.
Well, we've only got a little extract,
Yes.
and it starts with an account apparently being given to explain the last minute disclosure. But we aren't told what that explanation was. We simply go into a
Yes. Yes.
that's, I'm afraid, the point I was
Well, if my lord will
I
find it
hope
helpful
modestly
to have the email.
as expressing unhappiness about, that one always wants to see the document itself, not
Yes.
extracts from it. Could one or both sides get it out? It may turn out to be a red herring, but I feel much more comfortable having seen it.
Yes.
We can have it over after lunch, hopefully,
Yeah.
or even over lunch.
Perhaps, I mean, my essential point would be that whatever is said in the email by the respondent solicitor, which implies that the tribunal is just looking at Vinci, it doesn't absolve the claimants from the need to select a logical PCP and a logical pool. The burden remains on them as far as that's concerned.
But it sustains the tribunal's conclusion that you knew the case you were meeting. It mightn't have been a very good one, but you knew the case you were meeting.
That could potentially be said, my lord. It may be that the proper actually the proper conclusion on the facts that we've seen is that we've misunderstood the case we were meeting. If one was going to draw any conclusion from
Yes,
that email.
that's the cross purposes
Yes.
analysis, isn't it? That we were offered as well.
Yeah.
Standing back from this, we're looking at the decision of the AT that overturned the ruling of the tribunal on this point, and the ruling of the tribunal appears to have been placed simply on a straightforward reading of the documents. The other documents we've been shown, which is the closing submissions, the list of issues and so on, none of those appear to indicate that in writing the respondents here, the claimants below, were actually advancing the narrower Vinci only comparator pool rather than the wider outsourced workers thing.
We've
So-
never done that, my lord.
So
No.
in a sense, all of that it doesn't change anything. It's the words on the page for the pleadings, really, I think, isn't it? And they're either right or they're wrong.
Yes.
And the AT was either right to say they were right,
Yes.
right to say they were wrong, or they were wrong to say they were right.
Yes. Yes. So, my lords, those are. I mean, those are the materials. I think.
No,
one
that's
one
as
needs to see.
helpful as you could be. Thank you.
And the tribunal then ends up by accepting the narrower PCP, and we say, well, that's all well and good, and but as soon as the claimants have indicated that the PCP on which they relied only concerned Vinci workers in a disadvantaged group, it shed light on the fact that what was now being argued for at trial was not really a single unified PCP at all. It was two separate things: the policy of paying employees the London living wage, and on the other hand, a decision regarding workers on the Vinci contract. And the tribunal's findings of fact, we say, are entirely consistent with the analysis that what was now being argued for was no longer a single unified PCP.
Before we leave the pleading point, at least you might say at the beginning, where the tribunal said at the beginning of paragraph 5, that it was clear from the pleadings that the PCP relating to the outsourced workers on the contract awarded to Vinci, and that you understood that. I mean,
I say that's wrong.
on any view, you must be on strong ground in saying that it wasn't
Yes.
in the least clear from the pleadings that that is what the case was.
So if one looks at the tribunal's findings of fact that relate to this matter, you've got on the one hand a finding at paragraph 31 on page 110 of the bundle that the respondent and its predecessors have at all times been committed to ensuring that its employees are not paid less than the LLW. And you've got findings that on the occasion of deciding to award this contract, the Vinci contract, the respondent made a decision not to pay an LLW rate, and that's paragraph 37. But what you don't have is any analysis of a general practice. And one can't, we say, put those two things together at paragraph 68, as the tribunal did, and construct an artificial general practice out of those
But
two
why not?
points that are sort of bi-directional.
Why not? Why not?
Because the pool's illogical mode.
It's an instance of your general policy.
And if it's an instance of the general policy, one needs the wider pool, because you need all the people to whom the policy is applied, as a matter of logic.
You don't know if the pool is, the policy is putting people at disadvantage.
I understand that.
Until you know who those people are.
I understand that you contend that the wider pool was the right pool. That's not the point that I'm coming to, but I'm not understanding the two PCPs argument which you are returning to now. I mean, it's not two PCPs. It's you're operating one PCP in this particular context. It's the same PCP. I mean, I'm not sure that it disadvantages you particularly.
It may be that it's semantic,
just seems to be an unnecessary.
So you know what you're up against. I'm in exactly the same place as my lord, and I'm not sure this is your best point.
I think
Isn't it a simpler point simply to say that the pool they actually proceeded on was logically the wrong pool, and the pool they should have proceeded on, there was no evidence to support?
I think you're overanalyzing it by saying it's got to be two things. However it's described, whether it's one, two or more, it's got a fundamental flaw in it because it fails to include consideration of a section of the people that you say have got to be considered.
Subject to Mr. Khan's point that that is an assumption that the pool has got to be wider, because actually we don't know whether you had any control over the other contracts in the same way as at this stage of the argument we're accepting you did over the contracts that went, the Vinci contract.
Yes.
That's that is what you, seems to me, you've got to answer
Yes.
as a possible answer to the otherwise very straightforward
Yes.
analysis
Yes.
that I suggested to you.
Thank
Well,
thank you,
you
my
don't.
lord. No,
you-
no,
by all
that's-
means, look this gift horse in the mouth. We're thinking aloud here, but that's how I see it at
Yes.
present.
yes.
Don't promise to go on seeing it that way, but that's how I see it at present. I think it's how my lords see it
Yes,
as well.
exactly. Yes.
Well, no, I'm grateful, my lord, and I won't look that gift horse in the mouth. I mean, I think what I will do then is just turn straight to the grounds of appeal, and when dealing with those, deal with the point that my lord has put to me that's made against me on the evidence. So ground one of the appeal is paragraph 20 of my learned friend's skeleton, core bundle, tab 3, page 37b.
Just give me one moment. Yes, sorry.
Yes, so this is the erroneous interpretation of the ET1 point. And I mean, my answer to that is the one that I've given you, which is the AT clearly didn't mischaracterise it because the pleadings pleaded a wider pool, and you've seen the relevant bits. There's also a second answer, which is that the EAT in any event rejected the claimant's case on the basis of the alleged PCP pursued at trial and adopted by the tribunal. It didn't say we're determining this on a pleading point. And the pleading point in the EAT's judgment was addressed by means of background, because actually what the EAT wanted to understand is, just as my lords want to understand, is how the Employment Tribunal had ended up in this position of considering the pool at paragraph 68. And the EAT very fairly wished to explore whether the tribunal had misunderstood the case that the claimants were putting. It may just be worth turning up the EAT's judgment to see that. That is page 87 is the sort of first reference. Paragraph 81. One looks at the second sentence there, and exploring this question with Mr. Khan in oral argument, it was not suggested that the EAT had thereby analysed a more limited case than the claimants were seeking to pursue. And if one looks at paragraph 85 at the bottom of the next page, an interesting question had been raised by the claimant's pleaded case, which sought to raise the issue as to how contracting practices, out practices, might be said to be indirectly discriminatory in a way that was rendered unlawful under section 41. Unfortunately, the way this case was then analysed in the present proceedings is fundamentally flawed. This might be considered to have been a missed opportunity to engage with the issues identified by these claims, but having explored this question with the parties, we are satisfied it cannot be said that the error arose from a misunderstanding of how the case was being put at trial, such that it might be open to us to remit this to the ET for reconsideration. So that's really what the EAT was doing when it was trying to look at the pleadings and saying to Mr. Khan, well, you know, actually, were you trying to put a rather wider
But it's
case?
also relevant to the remittal point, isn't it? Because if you had had a misunderstanding which, as it were, persisted right up to the hearing and left everybody having been in a muddle, that's a classic case in which you might want to remit and get them to start again. Although there may well have been muddle on the way up to the hearing, by the time we got to the hearing, the case which the ET decided was the one that the claimants wanted to have decided.
Yes.
And no, there was no muddle that was disadvantageous to them.
Yes. Exactly that, my lord. And
I think that's right. Anyway,
Yes.
but that's how I see
yes.
it.
Yeah, and that is exactly the point I'm seeking to get to from these bits of the judgment. So that's what we say about grounds of appeal 1.
Do you mind, before we leave this, I just wanted to catch up with the intervening paragraphs because it's an important part of the.
Yes.
Read between 81 and 85 again.
Yes, and my lord, in fact, the beginning of paragraph 82 is also
That was what
summarized.
set me on it. Yes.
Yes.
Thank you.
And actually, by reading that bit of the judgment, it anticipates what I'm going to say on grounds 2 and 3
Yeah.
of the appeal, which in a sense run together in the claimant's skeleton. And those complain that the practical effect of what the EAT did was to place an unrealistic and disproportionate burden on the claimants to investigate all of the respondents' other contracts. That's the way it's put. And we say that repeats the fallacy that is identified by Mrs. Justice Eadie, which is of assuming that there is no means of getting information. And there were a number of things that could have been done, but were not done, by way of requests for further information, etc. And my lord asked yesterday about statutory questionnaires.
I was obviously wrong about that.
Yeah.
But you
But
can,
yes, it is of some note, in fact, that although that process no longer exists, in fact, ACAS do have a suggest on their website that further questions should be asked, and that no doubt.
yes, subject to time limit points, be everything to be said. If you were in any doubt whether it was even worth applying, you could ask questions in advance.
And the other thing that the claimants could have done, apart from asking for information, would have been to produce their own general statistical information, for example, on BME representation within the type of roles at issue. And it's of some note that actually, rather late, the claimants tried to do that in respect of cleaners. And one can see that from paragraph 59 of the Employment Tribunal's judgment, which is page 119. The point I make is a small one, which is just that that's the sort of thing that could have been done in respect of other roles and done before the hearing. It's just
Why would those be other roles? Information about the cleaning workforce. That would be the same role.
This particular information sought to be introduced was indeed about cleaners, but
Yes.
the
I see,
point I
I
make is
see.
very small.
It's not about gardeners.
Yeah,
No. So what do you say? If we know that there are 6 broad categories of outsourced workers, if they could have produced figures for park attendants, lockkeepers, and so on, hard to imagine them doing that. And then it would be up to you to say, well, you can't include those because, in fact, the contract provision is different.
Yes,
That's
I mean that would be the
all.
sort of information from which the tribunal could properly infer.
It's a very minor point.
It's a minor
the
point.
right way to
Yes.
do it, if the rest of your case is right, was to ask questions either before the proceedings or during them.
Or to get a proper case management conference with directions. About
Yes,
what-
I meant to ask questions,
Yeah.
including by that means.
Yeah.
Yes.
Yes. And then as to grounds of appeal 2 and 3, my lords, those are dealt with together in my learned friend's skeleton, starting at page 37G, so it's paragraphs 41 to 64. And the main point made here is that the EAT made what's said to be an unevidenced presumption that other outsourced workers were in the same position as the claimants, so that they ought properly to be included in the pool. And we say the EAT didn't make any presumptions at all about the characteristics of other outsourced workers. It simply pointed out the logic of the pool on the basis of the PCP. That's nothing to do with evidential presumptions. It's just an application of the principle in Allenby that the identification of the pool is a matter of logic. But also, it wasn't for the respondent to show that the appropriate pool should contain other contract workers apart from the claimants. There wasn't a burden on the respondents to show that point. If the claimants wished to contend that although the logic of their PCP was a wider pool, in fact, only Vinci workers should be included, it was up to them to make that case. And that is simply an application of the well-known principle on who bears the burden at this stage in Nelson and Carillion. My lord, would it help just before lunch just to turn up Nelson so that...
Yes.
So that's tab 11 of the authorities. And if one's doing it electronically, it's page 154. And that was a case where the claimant said, very much as here, that she knew about the statistics in her bit of the organisation. And if the respondent wanted to say that other people should be included in the pool, it was up to the respondent to produce the evidence to make good that case. And the Court of Appeal said that's wrong. One can see the facts from the head note. Claimant's a member of catering staff employed by an outsourcing organisation and is paid less than a male comparator doing the same job because he had protected terms under TUPE. And she said that those pay arrangements were indirectly discriminatory based on a pool of 8 employees in the wing where she worked, where 80% of men and only 66.66% of women had protected terms. And what those rather artificial statistics meant was that...
Yeah, we got it.
Yeah.
We're very numerous up here.
Yes. And the ET and EAT said, well, it's inappropriate to seek to compare numbers in such a small pool, and the appropriate pool is catering staff across the whole hospital. When the matter got to the Court of Appeal, the claimant raised a new argument, which is that once she'd raised a credible case of discrimination, it was up to the respondent to disprove it. one sees that at the end of paragraph 18 on page 161. And Lord Justice Simon Brown then considered the case law on the burden of proof in detail at paragraphs 21 to 35 and concluded at paragraph 36, page 166, that in an indirect discrimination case, the burden of proving disproportionate adverse impact lies on the complainant, and merely to raise a credible suggestion that were the relevant, valid and significant statistics provided, these might establish disproportionate impact, it is not sufficient for the complainant's purposes and imposes no further burden of explanation on the employer.
There was some discontent with this decision when it came out, but it has never been overturned, and I think people have gradually come to look at it more favourably than they did. But anyway, it's binding on us. So
Yes.
yeah.
And we say that what the claimant's second and third grounds of appeal are doing in this case is the equivalent of the hospital wing approach in Nelson, because they say, well, we only know about our own contract, no evidence about other contracts. Those workers in those contracts might not appropriately be in the pool at all. And the answer to that is, well, you pleaded a PCP which logically requires that analysis to be done. The burden is on you. So that's the Nelson point, my lord, and it is now a good point at which to.
I think it probably is, yes. You're not, well, you may be a little bit longer because the respondent's notice points, well, we're going to finish certainly well within the afternoon. You are, and I'm therefore Mr.
Yes.
Khan.
And I'm conscious of the need to leave Mr. Khan enough time for the time.
Yeah.